Number 37, Nadkos versus Preferred Contractors Insurance. One moment, Counsel. Good afternoon, Counsel.
Good afternoon, Your Honors. May it please the Court, my name is Dwight Stevens. I'm appearing on behalf of Plaintiff Appellant Nadkos, Inc., and with the Court's permission, I'd like to request 2 minutes for rebuttal.
You may have 2 minutes,
I
sir.
apologize for my laryngitis.
Are you all right? Do you want a drink of water?
No, I'm fine. That won't help, Your Honor. I can appreciate it, though. The course that PCIC charted in this case from the beginning was, see Wadsworth, we win. It answered without asserting any affirmative defenses, it produced its policy, and then it moved for summary judgment based on Wadkos. Wadkos is a good case. We relied on it when we represented a risk retention group in the Garcia case in the Eastern District of New York, but it's not applicable here. In Wadsworth, the case made clear that the plaintiff was not seeking to come within one of the exemptions to the Liability Risk Retention Act. They were trying to say that the very broad direct or indirect regulation language did not apply to it, which was the direct action language in insurance law 3420A2. When it comes to the exemption provisions, they are separate. The Act makes that clear. Wadsworth also supports that. The exemptions, A through I. A, the first one, a non-domiciliary state can regulate a risk retention group with respect to its unfair claim settlement practices.
So the issue here is whether subdivision D2 is an unfair claims settlement practice, right?
That's correct, Your Honor.
And we have defined what we consider to be an unfair settlement practice, or at least in 2601A, we called it a failure to comply with the disclosure requirements of 3420D, right?
Correct, Your Honor.
Okay. So why would the legislature use the word disclosure requirements if it was referring to both
Paragraph D1 and D2.
That's right.
Because they both require disclosure.
Okay, but do you not agree that there's a difference between confirming and specifying coverage versus disclaiming coverage? You don't see any difference in that?
See, they're flip sides of one another, Your Honor. Paragraph D1 requires an insurer to promptly confirm the existence of coverage with respect to certain personal liability policies. Paragraph D2 requires insurers to promptly deny coverage in all liability policies for policies issued or delivered in New York State.
How is that disclosing coverage if you're denying it?
Well, the dictionary definition of disclose means to make known or reveal. If somebody asks you for coverage and you have an obligation to deny coverage, that's a disclosure requirement. They're just flip sides of one another.
But isn't the statutory history, and I'm not really talking about the legislative history here, but the history of the statute itself, undermine that argument? Because originally it was just disclaim, and 2601 didn't cross-reference this. And then they added the disclosure language as a separate subparagraph, and then the disclosure cross-reference was added in 2601. Doesn't that really undermine that argument?
It doesn't, Your Honor. I think that they put when they reference, first of all, with respect to a plain meaning argument, we'd argue that D means D1 and D2, unless you can say that one of them does not have a disclosure requirement.
Let's say you've got that argument, which is a valid argument, but you've got the point that Judge Stein was just making on disclose. So let's say that creates some ambiguity, and we look at that statutory history, let's call it the enactment history. Why doesn't that clear it up? Because when it was only disclaimer, it wasn't an unfair practice, and when they added disclose to it, it became one, and the cross-reference to disclose was added to 2601.
Well, Your Honor, if you look at the the executive legislative history in this case, and that would be what was cited by Judge Wilson in the Carlson case with respect to the issued or delivered language under Insurance Law 3428-2. It's part of a much broader amendment
The case I
package.
dissented in, right?
You did, Your Honor, yes. That was 4-3. There aren't too many, especially in statutory cases. So you may remember that, the issued or delivered language and that legislative history. I looked at it again in connection with preparing for this argument. And there, I think you'll see, first of all, the light went on. This is part of a much broader amendment package. They didn't just add D to 3420 and add it to the Unfair Claim Practices Act. It was part of the statute which tried to get away from the late notice, no prejudice rule in New York. That was a big thing. And so in connection with that, the legislature amended that to say that that injured parties could commence declaratory judgment actions against the defendant's insurers, and they also made it so that you had to have prejudice. So in connection with that legislative history, the insurance industry came in, and they said they recognized that New York State was out of the mainstream when it came to having a late notice, no prejudice rule. The other states didn't have that. It was a thing. They wanted to get back in the mainstream. But the insurance industry said, but while you're at it, we reoppose the bill because it doesn't also change 3420 D2, which is also unfair. They believed that the late notice, no prejudice rule was unfair because it was an unfair technicality because it barred coverage based solely on the passage of time. The late notice disclaimer rule, which is invalidates otherwise a valid disclaimer based solely on the passage of time, was also unfair.
Well, you seem to minimize the difference between the consequences of violating D1 and D2.
Correct, Your Honor.
Why aren't those consequences relevant in determining whether it was intended to fit within an exemption from the preemption, right? Which we know that the preemption was intended to be broad. You agree
Yes.
with that, correct? So
There's
why
nothing-
why isn't that a relevant consideration?
First of all, there's nothing in the statute that says that there's this broad preemption and that broad preemption can trump the exceptions in some circumstances.
Well, even further, I mean, the legislature, if they wanted to, could have said it was specifically referring to D1 and not to D2, and they didn't do that.
Right, that's our main argument.
I don't know if it's a winning argument, but it is a point in your favor.
Right, and
Well, but we're back to disclose coverage, because the point is that 2601A6 is specifically referring to only the part of subsection D and F that refers
Makes
to
to
disclosure of coverage.
A
So
big
I
part
don't
of
think
it.
the fact that it's one or two is the point. The point is, let's look for that language or that part of the statute that deals with, or these sections that deal with disclosure. And so we're back to where Judge Stein first asked you about how we can make these
And that's
distinctions.
a big part of it. That's a big part of it, whether or not you believe that paragraph D2 is a disclosure requirement. One thing I would add is that, and what I was trying to get to with respect to the legislative history part, is
Well,
that...
your argument seems to me to be any revelation regarding the policy and the coverage is covered, as opposed to something that is specific regarding coverage. So that's why you say a disclaimer would fit.
It's, well, I guess
Any bit of information that's provided. And that strikes me as counter to the choice of particular language here, because otherwise this would just say information.
no, but the point I want to make, and it's a big point, is that 3420D2 is an extremely important provision in New York State. It has an enormous public policy significance. This, as demonstrated by all the cases construing it, including this case, this court's cases in First State versus
But
Financial.
that begs the question of whether it can apply to a non-domiciliary risk retention group, which the federal government has said, we want to protect those groups. We don't want them subject to all these important policies of so many different states so that it makes it difficult for them to operate. So the importance to New York, it seems to me, is secondary.
Not when it comes to one of the exceptions, which is claim settlement practices. And 3420D2 is an extremely important claim settlement practice in New York. When they put it in the Unfair Claim Practices Act as paragraph D, part of that is to confirm its public policy significance.
Judge
you're-
Garcia has the last question.
Thank you, Chief. You raise an interesting point. On 2601, the unfair claim settlement, what's the purpose of that statute? Outside of, yes, we look to it for preemption for these purposes, but generally, what's the reason things get listed under 2601?
I think it's to indicate what's the public policy importance to the state.
But it also,
I mean,
it
it
provides
has-
for penalties,
It
right?
does, but that's not a very big deal.
But who enforces 2601? Outside of the context we're talking about, who enforces these unfair claim settlement practices?
I think the insurance department.
And do you have any indication that they've ever enforced that disclaimer provision as an unfair claim settlement under 2601? Have they ever penalized an insurance company for that?
Your Honor, and they don't have to, and that's one of the ironies here, because 3420D2 speaks for itself. Nobody's going to do that, and nobody's going to violate it as a general business practice because you're going to have an invalid disclaimer if you do. But that doesn't mean that the legislature
So they've
didn't intend-
never enforced any of the provisions? They've never enforced D1 or D2 in terms of penalizing companies under 2601?
I don't know whether they have or not, Your Honor, but I'm just saying that I would think that they would not have to penalize anybody for 3420D2 because it has such a serious
Then why
consequence.
list it? What's the effect of 2601 if you have?
Just to confirm that it's of public policy importance. I recognize you don't necessarily need it. First Financial's been cited as of this morning over 1,300 times.
Thank you, counsel.
Sure.
Counsel?
Good afternoon, Your Honors. Diane Bucci, may it please the Court, Diane Bucci for Preferred Contractors Insurance Company. Counsel's point is very well taken. Why add it to the unfair claims practices section when D2 does speak for itself? And there would be there's no benefit to be gained by including 3420D among those practices that.
Well, what's the benefit of including D1 then?
Well, the benefit of including D1 is that D1 has no other enforcement mechanism, but the superintendent of insurance can address to the recalcitrant insurer, the recalcitrant insurer, that it's not doing what it's supposed to be doing.
And to your
it's
knowledge,
subject
has
to
that
a fine.
happened?
I have no idea if that happened, yeah. Also, I just want to point out that this court and many others have separated the concept of coverage qua coverage from the concept of exclusions and conditions. And in this case, we're talking about disclosing coverage. So what does disclosing coverage mean? Does it mean denying based on exclusion and conditions, or does it mean specify limits and provide the fact that a policy exists? And I think that
Go ahead, ma'am, you finish.
And I think that to answer that question, we look at the section that's included with A6, which is 3420F2A, which specify you have to disclose coverage, and that section specifies that the disclosure of coverage means the disclosure of limits and the existence of a policy.
I think it's fair to grant that there's a difference between disclosure and disclaim. That's been the insurance company practice in the case law in New York forever. But what I'm wondering about is if this wasn't PCIC, wasn't a foreign corporation, would this be considered an unfair claim settlement practice if it was purely a New York company?
No, however, if it were a New
Wasn't the
York...
70s, let me just finish here. It's 77 days on the notification, right? You're saying that that wouldn't be an unfair claim settlement practice?
No, it would be a disclaimer under 3420D2.
So the exclusion wouldn't apply?
The exclusion would not apply.
So it would be a
right.
disclaimer,
A New
the
York
exclusion, let me just
insurer-
finish. It would be an exclusion, the disclaimer wouldn't apply, but you're saying, but the policy itself would still be in effect. And they're, right.
Right.
Because it wasn't a question of disclosure, it was a question of disclaiming as to an exclusion.
Right. And the risk retention group mandates, if you will, are set forth in New York in 5901 et sec. 5903 explains that New York insurers have to comply with all of New York statutes, laws, and just like any admitted insurer. But that's different from exactly what the LRRA is attempting to do, which is to stop the provisions of non-domiciliary states from governing a non-domiciliary foreign risk retention group.
So let's say we conclude that 3420D2 does not come within 2601A6. Say we agree with that. Is that where our inquiry stops? Do we then have to decide whether or not it's preempted?
Right. Well, I would say yes normally. However, I don't think that issue was appealed to this court. I think the issue appealed to the court was a question of whether 2601 included 3420D, both 1 and 2.
But isn't the only reason you're asking that question because of the preemption issue?
the preemption
Otherwise, why
issue.
would
Right.
anyone care?
That's right. And I think that Wadsworth is very clear on preemption and the purposes behind preemption and the importance of it. And in the papers, counsel speaks to this terrible, horrible litany of horrors that would occur if we allowed risk retention groups to operate the way that Congress intended. But first of all, that's what Congress
Well,
intended.
the only question is about 3420D2, right? Just that. That's the only one you're trying to argue, that's the only one your position is preempted, correct?
That's the only one my position is not an unfair claim settlement practice.
To fall within an exception. My point is,
Of
why are we
preemption.
concerned about the exception if it's not, if it's not something that would be preempted in the first instance?
Right, and I
So your position is it's, right, it's preempted, correct?
it's absolutely
Okay,
preempted.
all right.
My position is that Wadsworth makes clear the public policy purposes behind preemption.
Mm-hmm.
And also, in this particular case, counsel speaks a lot about illusory coverage here, but we're talking about an exclusion that would apply, that there's no question New York State has applied ad nauseum these employer liability exclusions. This is an employee of the named insured, and the exclusion would apply, but for 3420D2. So it can't be catastrophic for it to apply. It would normally apply. And there is also the issue of the general practice.
Well, that's not preserved, is it?
I'm sorry?
That's not, that argument is not preserved in the court of instance?
Did you raise it before Supreme Court?
Yeah.
You did?
Is it in the papers?
I believe it was raised before the Supreme Court, yes.
They've argued it was
Well,
only raised at the
actually-
appellate division at oral argument. Where is it in the
Right,
papers?
no, well, the Supreme Court raised it sua sponte.
And where would we find that?
Record, Okay, so record page 25. Just one untimely notice does not arise to the level of an unfair claim settlement practice. So, may I continue?
Yes, please.
Okay. So coverage in this case is not illusory. It's a normal, standard coverage exclusion. There's no problem with it applying. It applies generally if now, PCIC did disclaim coverage timely to its named insured, which was my general practice point, is to show that we don't have a general practice of doing this. And I believe that foreign risk retention groups would attempt to comply with 3420D2 because we try to be prompt in every state.
Let me ask the question that was previously asked a little bit differently. Assuming, and I don't have the record in front of me right now, that, as you say, Supreme Court raised this issue sua sponte, is there any evidence in the record in the trial court regarding whether this was or was not a general practice, other than just attorneys' arguments on the point?
There is absolutely no evidence to show that it was a general practice.
Okay, wouldn't that prevent us from making a finding of fact on that point? Are you saying that if it was a material issue, if it wasn't academic, we would need to send it back to the trial court to make?
Well, I think that the court made the finding of fact.
You're saying, in this reference to the record, you're saying that's a finding of fact, that there was only one incident? As opposed to simply stating a point of law?
There were a couple of incidents, not one incident. There is a case that's been cited by counsel Aramdan where PCIC was late in disclaiming coverage, and we won at the trial court level in that case.
Okay, so you're saying that if that's their proof of a general practice, that's not enough?
Right.
Okay.
Right.
Thank you, counsel. Counsel?
With respect to the general practice point, it was never briefed below in the motion papers. We went through the whole oral argument and was never raised by counsel or the court. The court took a half-hour break, went out, looked at the Aramdan case again, came back, and came up with a bunch of reasons from Aramdan, including the fact that one incident of a violation would not constitute a general practice. That had never come up at any time before that, wasn't briefed again. We believed that they had decided to abandon that argument because it's not a winning argument for them, because you can't have a situation where a company is taking the corporate position that this does not apply to us and we don't have to follow it. In a legal proceeding, they're taking that corporate position. Our argument is that that's evidence in the form of a court filing of an admission of a general business practice. You got the corporation coming in and saying, we're not going to abide by 3420D2. You don't need to do discovery and so on.
Before your time is up, I just want to clarify a point, and I think Judge Rivera raised this. Do you concede that if we conclude that this was not an unfair
Yes, Your Honor, it's preempted.
claim settlement, it is preempted?
Yes.
Okay,
That's as far as you need to go.
thank you.
Oh, wait a minute, when you say that's as far as we need to go, you mean all we need to do is decide
Well-
whether or not 3420D2 is encompassed under 2601A6? And we don't then need to also say, or initially say, that 3420D2 would be preempted unless it falls within an exception?
No, I think you need to, I guess it's more complicated than I realized. You need to figure out whether or not the reference in paragraph 6 of the Unfair
Yes.
Claim Practices Act, which references paragraph D of
Yes.
Insurance Law 3420, it encompasses 3420D2.
Yes.
And if so, then it is a claim settlement practice and can be regulated by the state as a non-domiciliary.
But for the purpose of this appeal, if we find that it is not an unfair claim practice, the parties have stipulated that it is preempted. Is that right?
We haven't stipulated, but that's
Well,
the fact.
You haven't, okay, you're not disputing that.
Not disputing that, yes.
Well,
I mean, if it's preempted, the case is over.
I'm not understanding this position. Why would one be looking at an exception if you had not been arguing that it is or is not preempted? One does not look for the exception unless it falls within the general preemption rule.
So first, you look at whether or not it is an exception. The exception is the regulation of claim settlement practices. Then you look at it at the unfair claim settlement practices, 2601A, in this case, paragraph 6, and it references insurance law 3420, paragraph D. So then you look at and decide whether or not D includes
No,
D1
I
and
understand that
D2.
you've explained, yes, we understand your argument there. I'm not understanding your response to Judge Wilson, who's asking, I think, are you conceding the preemption? Or did you always take the position that it is preempted because that's the state of the law, and so you don't dispute it that way?
I'm not sure I'm understanding.
Is there any argument that you can see for why it would not be preempted other than this exception?
No.
And you've never made such an argument?
No.
Okay, thanks.
Yes.
Thank you, counsel.
Your Honor.
Thank you.